My name is Kerry L, and I'm the Deputy Executive Director and Counsel for ConsensusDocs. ConsensusDocs is a coalition of 39 leading design and construction industry associations. I want to thank you for joining us for today's 90-minute webinar. Our panels will provide you with an introduction to teaming agreements and discuss critical elements, especially in light of the recent CyberLock case. You will have an opportunity to ask questions of our speakers. Please type your questions in the questions box, and we'll address them at the end of the presentation. A copy of the PowerPoint and webinar recording will be emailed to you several days after the webinar. I would now like to introduce our esteemed speakers, Kory George and Kerry Kester. Kory has practiced law with Woods & Aitken since 2003, with an emphasis in construction law and commercial litigation. His experience includes advising and representing contractors, subcontractors, suppliers, manufacturers, owners, design professionals, sureties, and financial institutions in all aspects of claim and dispute resolution proceedings, including mediation, arbitration, and litigation at the state and federal court levels. Kerry Kester has practiced with Woods & Aitken since 1981, focusing on construction contracting and dispute avoidance and resolution, including contract negotiations, project management, and lien and bond claims. He has appeared before state and federal courts, administrative agencies, and the Federal Boards of Contract Appeals. We're very lucky to have such prominent construction industry attorneys for our presentation today. And with that, I'll hand it over to Kory and Kerry.
Thank you, Kerry, and thank you everyone for joining us here today. My name is Kory George. You'll hear from Kerry Kester here as well over the next 90 minutes. Give you an overview of what we're going to cover today. Initially, we're just going to talk about teaming agreements, generally why we use them, what they are, what they're intended to do, those sorts of things. And then we're going to raise some of the issues that we see in teaming agreements. And we're going to take bullet point 2 and 3 together as we work through here these today, because as some of you know and maybe tuned in to hear, the ConsensusDocs has published a new agreement, the 296, which is the teaming agreement. Kerry and I both participated in the drafting committee for that document, and so as we raise issues here today, we'll tell you how the teaming agreement, the 296, deals with those issues or doesn't deal with them in some instances, and why that is. And then we'll work through that, and then we'll end it with talking about the legal landscape and some drafting considerations depending upon your perspective. And so as Kerry L mentioned, there's some recent cases out there that have caught everybody's attention, the CyberLock case being one of them. We'll talk about that in the context of the 296 and some of these other concerns that we'll raise here today. Starting off at the beginning, there's not always a universal definition of even what is a teaming agreement. If you ask 10 different folks, or you go Google what is a teaming agreement, you'll get different answers on that. I'm going to provide you with a couple of definitions here that are out there. One is in the C.F.R, the Federal Acquisition Regulation. It defines what a teaming agreement is in the context of federal procurement. And if you look at the slide here, it actually has two definitions. One being two or more companies teaming up as a partnership or a joint venture. So that's a pretty broad definition. Just for you folks here today, when we're talking about the ConsensusDocs 296, we're talking about a teaming agreement, and not necessarily a joint venture. There is a different document for that, and we're going to talk about that briefly as we work through here today. But at least the C.F.R definition of teaming agreement is broad enough to encompass a joint venture, but that's not what we're talking about here today. The other sort of second definition in the FAR is a prime contractor agrees with other companies to have them act as a subcontractor under a particular program. That's by and large the relationship that we're going to focus on here today, is where one team member acts as the leader and submits the proposal, and it intends to subcontract with one or more of its team members on a prime-sub relationship. That's not always the case, but by and large, that's most common, and that's the context we'll probably focus on for the most part as we work through the slides here today. Another definition that's out there, the General Services Administration has its own definition of what a contractor team arrangement is, and as you can see, the 2 or more GSA qualified contractors working to meet the agency requirements. The point of this is that there are several definitions out there of what a teaming agreement is or isn't. For our purposes here today, what we're really talking about is 2 or more companies getting together to present a proposal to obtain a specific award. You can have teaming agreements that are broader than just one project, but that's the 296, and for the most part, from what we see, teaming agreements are geared at a specific project. And so you have 2 or more companies teaming up, and what is the relationship on the front end in terms of exchanging confidential documents? Are they going to be able to compete outside the team? And those are the concerns that we're really focusing on here today, and the context from which we're going to speak about teaming agreements generally. And with that, I'm going to turn it over to Kerry to talk about why do we enter into these things in the first place.
Thanks, Kory. Good afternoon, and thanks so much for joining us in this webinar. I want to just continue on here with this theme of some of the introductory reasons that teaming agreements are used and why they've become so popular. And I think first observation I might make is that they really have become popular, and their use has really grown, particularly in the area of government contracts. And I think also it's been a function and part of the growing popularity of design-build as a project delivery method, as well as other alternative delivery methods and integrated project delivery concepts, lean, various types of collaborative approaches to project delivery. They more or less demand some type of arrangement by which multiple contractors can get together and develop their proposals and determine the best way forward in terms of meeting a particular agency procurement requirement. In the design-build context, ConsensusDocs also has published the ConsensusDocs 498 teaming agreement, which is specific to design-build projects. And so to the extent that your teaming arrangement involves a design-build project delivery, that's a form that is going to help set some parameters for that type of a teaming arrangement. I think in terms of the government procurement, the growing popularity of two-part procurement and the use at the federal level of multiple types of alternative project delivery also have spawned an increased use of teaming as a way of addressing those government procurement issues. I think one of the other areas that you see a growing use of teaming is in the implementation of the socioeconomic programs, contracting programs at the federal level, the small business, disadvantaged business, and programs such as that, which tend to link up contractors at the beginning through some type of collaborative arrangement that helps the smaller disadvantaged contractors succeed. I guess another observation that we've made over the course of the last several years is that in the teaming context, the most popular or most common occurrence or use of teaming is where you have more of a prime sub relationship, prime contractor, subcontractor scenario. To the extent that you've got parties that, as Kory mentioned earlier, are perhaps more prone or desirous of entering into these things in a joint venture or more of a partnership arrangement, the joint venture agreements that we've talked about just briefly probably are more conducive to facilitating your collaboration on that type of an approach. Another consideration, I think, for many people is that teaming agreements, fall, and Kory alluded to this earlier, they fall into that category of agreements which can be characterized, depending upon the language and the details, might be characterized as agreements to agree, which, of course, raises enforceability issues depending upon, again, the many variables that go into that type of analysis, as well as depending upon the particular jurisdiction or governing law applicable to your agreement. And so enforceability obviously is one of those threshold considerations for the parties when they're entering into teaming agreements, to the extent that they desire the ability to enforce specific aspects of their arrangement. It behooves them to address the details, address the specific rights, as well as the particular remedies that may be available to the team members in order to assure that they have the level of enforceability that they desire going forward. The reference there to the CyberLock case, and Kerry L mentioned that earlier at the introduction, and the CyberLock case is another in a long line of cases that provides an analysis for when and under what circumstances these types of arrangements or agreements may or may not be enforceable. And Kory, I know, will address that in more detail later on in our presentation. The next thing we want to address is some of the uses for teaming arrangements and what they can do. And I think quite obviously, or should be apparent to everyone, that one of the main reasons for teaming is to leverage the capabilities of multiple contractors and basically bring together the best of the best in order to form a team that offers a much more competitive and attractive alternative to the owner. It also opens up opportunities where a particular contractor may not have as strong a set of resources, human or otherwise, and they're able to team with a company that has complementary strengths in those areas. It enables them, again, together to present a much more attractive alternative for the owner, thereby arguably increasing the opportunities for both businesses. The next thing you look at is reduced financial or technical risk, and I think here, while it's probably not appropriate to view these arrangements as eliminating financial risk, they can certainly address some of those things. And one example of that is oftentimes the choice might be for a contractor to either team up with another contractor or to develop certain strengths, certain abilities in-house. That, of course, the latter would require an investment of financial resources, human resources, and particularly over the course of the last 5 or 6 years, companies have been going the opposite direction in terms of slimming down and becoming leaner and meaner. And so teaming offers an alternative by which you're able to continue to compete without making that additional investment of financial and human resources. From a technical risk aspect, to the extent anybody is getting to the edge of their wheelhouse in terms of their technical abilities and their know-how, it behooves them to look, again, either inside by growing talent and recruiting talent inside, or in the cases that we most often see, they're reaching out through a teaming arrangement to bring on that technical expertise. Obviously, teaming can be helpful in terms of market entry, providing opportunities to get into a market area by the lending of resources and technical ability from other companies, and similarly resolving financial difficulties, I guess. And again, I don't want to suggest to you that you can solve your financial problems through teaming, and in a lot of ways you take on risks anytime you increase your relationships and complicate them. On the other hand, when you're trying to look at it from the point of view of a proposal and how your proposal looks to the owner, oftentimes the financial strength of the team, can overcome the particular weaknesses of any one of its members, and that can be a helpful thing. And finally, the experience and performance requirements of the owner obviously can be addressed more thoroughly when you have the entire range of talent available through your team members. And so that's obviously another reason to use teaming. On the other hand, there are a number of things that teaming arrangements should not be used for, and that is, first of all, to reduce competition. I think anybody who's spent 5, 6, 7 years defending bid rigging investigations like I did early in my career, you always your ears perk up anytime you see competitors coming together. And I guess the good news for folks is that over the last 10 to 12, maybe 15 years, the Department of Justice, the Antitrust Division in particular, have come to recognize the economic value of teaming and joint venture arrangements. And again, as long as they're used with economic motivation rather than for the purpose of reducing or eliminating competition or restraining trade, those things can be done without risking a jail sentence. On the other hand, if that's your sole motivation in getting into it, and you're simply allocating projects or setting prices, obviously that's going to be a problem. That's not a recommended use for the teaming arrangement. Eliminating risk. Again, I don't know that you can argue that teaming is going to eliminate risk. It's probably not appropriate to view it as a risk-shifting mechanism or tool. That's not its intention. And again, to the extent you, increase your relationships and complicate your coordination obligation through the use of team members, that's going to add some risk in that sense. But overall, the reward has to be something that is worth it. Obviously, corporate espionage is not a good reason for entering into a teaming agreement. Again, should not view this as an opportunity to get a sneak peek under the covers at another company's proprietary technology, or to get perhaps develop relationships with some of their key technical people with a view toward hiring them on to your own company. As we talked earlier, it's not a mechanism for eliminating your financial problems. Again, you're going to have to address those as a team in terms of dealing with any proposal to an owner, and similarly with past performance problems. Those are going to have to be addressed. They're not going to go away just through the use of a teaming arrangement. So. Another thing we wanted to touch on just briefly is some alternatives, I guess, to teaming arrangements. And we've mentioned one of them already, and that is the use of joint venture agreements. And, I tend to look at these alternatives in kind of a progression of intimacy, if you will, in terms of relationships between companies. On the stranger meets stranger end of things, you have confidentiality agreements. These are used most commonly in due diligence situations where you're trying to more or less take a peek under the covers at another company, find out what they are about, see if they are someone with whom you want to do business and might make a good potential teammate for a particular proposal. They're used in merger and acquisition situations, but they're all also appropriate in terms of seeking out and investigating the other companies who may or may not be good teammates for a particular procurement. Letters of intent, on the other hand, are used typically to signal a particular level of commitment by one of the team members to another. And memorandum of understanding can be used as well by, when both parties want to articulate a level of commitment and set out at least a structure, an agreement on how they're going to proceed going forward in terms of moving towards some kind of an agreement. We already mentioned, obviously, joint venture agreements, where you already have a working relationship with a particular set of team members. You've done 2, 3, 4 projects together already. Let's skip the preliminaries. Let's get to it. We know how we want this structured. Let's get the joint venture agreement in place right up front. Move forward with the proposals. If we get it, we've already got our agreement in place as to how we're going to manage this. We're going to share the risk with the owner rather than just having a prime-sub relationship. And typically, that's the key difference between the use of teaming agreements versus joint ventures. That is, in the joint venture, you really have a partnership of companies which all of which share in the fruits and the downsides of the owner-contractor agreement.
Switching gears on you folks now, we talked about teaming agreements generally. We're going to move to what are the issues that arise in the context of these teaming agreements. And by and large, there's a couple of categories that the issues fall into. One is the pre-award, that is the proposal stage. The parties get together to pursue a contract award. There's a number of issues that can happen at that stage. Then, of course, is the issues that, God forbid we get the award, then what? So there's a series of issues that arise after an award is made to the team or the team leader, as the case might be. And then there's a separate issue of what happens if before or after an award one of the team members withdraws because they want to or because the other team members don't want them anymore. There's a separate issue there. So we're going to go through those kind of in those broad categories, starting first with the pre-award issues. The initial issue is when you're constructing this team is what is the relationship and what is the responsibilities, or as I like to call it, who's going to do what. The Consensus Docs 296, and we're talking about the agreement in particular as we roll through some of these issues, that the 296 uses a team leader, team member concept. And so the team leader can be whoever the team designates as the team leader. Almost always that's going to be the team member that will receive the actual award from the owner. So they're in charge of the other team members by and large. And in terms of the specific duties, if you have 3 team members, what is each party going to do? The 296 deals with that issue a couple of different ways or alternatively. If by default the 296 says the team leader is going to decide what the team members are going to do. And so it may be evident because one or more of the team members may be strong in a particular area. That's why they team to begin with. And so the team leader can allocate who's going to work on which part of the proposal. If the parties do not like that default rule and they want some more specificity in how they go about things, there is an Exhibit A, or the 296 contemplates an Exhibit A where the parties can specifically lay out what exactly each party is going to do, both on the front end in terms of submitting the proposal and in the event that an award is made, what each party is going to do in terms of their scope of services. If you've seen it or you're purchasing the 296 and you wonder where's the Exhibit A that goes with it, there isn't one. And that is intentional. As the drafting committee tried to put together a one-size-fits-all agreement, it quickly became apparent that it's just an impossible task to try to lay out by default who's going to do what, both on the front end in the proposal stage and in the event of award. And so the 296 contemplates or allows for an Exhibit A that the parties would separately create and lay out their specific duties should they so choose. If you just grab it off the shelf and use it, the team leader decides that by default. Sticking with the pre-award stage of things, or the proposal stage, next issue that comes up is the submission of the proposal. How does that get done? Who controls what goes into it? Those sorts of issues can arise at this stage. Here again, the 296 says kind of generally that the team members are going to jointly prepare the proposal. That's a general platitude, and hopefully it works, that everybody's going to get along and agree on all aspects of that. The question comes up, what if the team disagrees? Well, the default rule in the 296 is the team leader makes the final determination as to the form and the content of the proposal. So in other words, if there is a disagreement, the team leader can break the tie and decide how the proposal is going to get submitted. And so you might say, well, we don't like that as a team member. We don't want a proposal submitted that we participated in if we disagree with it. And the answer to that is the situation in a joint venture scenario. The consensus docs, we're not going to talk a lot about it, but as one of the alternatives, if you want to get to that level of specificity, the consensus docs, the agreements, there are several of them, but one of the conditions on that, the default rule is if all the joint ventures in that context cannot agree, the proposal doesn't get submitted. That is not the case as a default rule in the teaming agreement context in the 296. Team leader gets to decide if there's a disagreement. The next issue is, what does it mean for the team members in terms of separately pursuing the same project? And we're going to talk about this a little bit more later in the context of a case. But by and large, most teaming agreements have an exclusivity or non-competition. I know Kerry said earlier it's not to reduce competition, but the point of this is if we agree, we sign a teaming agreement, for the most part, the team members expect that they're not going to separately, one of the other team members is not going to separately try to win the award without the other, without the team. And that's the case in the 296. The default rule is no team member can participate in the selection process of the owner except as a member of the team. So in other words, if you're a member of the team, you sign the 296, you cannot separately submit an award in your own name or with a different team member. That's just the rule. Obviously, the parties are free to modify that, but that's the default rule in the 296. There are a couple of exceptions to that. One is if all the parties agree that they can separately compete, then obviously there's agreement on that. The other exception is, what if the prime contract gets awarded and for whatever reason the owner doesn't want one of the team members to be involved? Well, sort of best practice, the committee thought was we don't want to put the team leader in a position to be awarded a contract and then have to violate either the prime contract or the owner agreement, as it's called in the 296, or the teaming agreement. So there's a fail-safe there. If for whatever reason the owner agreement says you can't have one or more of these team members, whether it be a licensing issue or a past performance issue or whatever the issue might be, there's a carve-out for that. Another issue, and Kerry talked about this briefly at the front end, is confidential information. You may enter into a confidentiality agreement at the outset merely to take a look under the covers at another company, as Kerry said, but if we're at the teaming agreement stage, certainly there can be and likely will be an exchange of confidential information or other proprietary processes from one company to the next. such as the nature of putting together a bid or a proposal. So how do you protect that kind of information? The default rule in the 296 is confidential information is protected from third parties. The only wrinkle to that is the parties must designate it as being confidential. So there is not in the 296 a presumption that everything you receive is confidential, but if one party supplies information to another, they designate it as confidential, there's a baseline level of confidentiality in the 296. But the 296 also contemplates that that may not go far enough. Some of this stuff may be highly sensitive, and the parties may want to put in specific remedies of what happens if that confidential information is misused, whether that be, damages or, specific return of the confidential information. That can all be laid out separately, and the 296 agreement not only contemplates and allows, but encourages the parties to execute a separate confidentiality agreement. Again, there is not one provided for the parties just because, frankly, the committee couldn't agree on what that should look like in a one-size-fits-all. And so the way it's left is if one of the parties wants to condition the furnishing of their information on a separate confidentiality agreement, they can do that. The next question comes up is how do you get it back, and when? There's a separate issue for team members that withdraw, which we'll talk about for a moment later, but as it applies to the team, the default rule is team members must return everything 30 days after the contract is finished. I suppose there could be a termination, or the owner decides to not award it at all or to another company. And so there's a built-in time frame for the return of that information as a default in the 296. Again, the parties may want to go into that in greater detail in a separate confidentiality agreement. The last issue that we're going to talk about, at least at the pre-award stage, is what happens to the ownership of documents. Who owns them and how can they be used? The default rule, and this would particularly be the case in a design-build context that Kerry talked about. Again, there's a separate agreement for that. A lot of these issues are the same, but this is one place where it deviates slightly. In the 296, even though it's probably not a design-build, a non-design-build type project, there still could be intellectual property that gets created as part of the bid submission stage. The default rule here is in the 296, each team member keeps the copyright and the ownership of all the documents they generate in furtherance of the proposal. So if they're creating or designing something or they want something is proprietary, the company that supplies it keeps it. The team members must then transfer that, a non-exclusive limited license for purpose of the project only, to the team leader. So that prevents, in the event of an award, that the team members can't hold the team leader that gets the award hostage or change its pricing on some intellectual property. Team leader gets to use it, of course, gets to use that information. they can arrange for payment of that, but as a default, if you create it, you keep it, but the team leader gets to use it, is how the 296 is set up. If the team leader does use it, they do so at their own risk, except for if there's a patent infringement, then the party that created that gets to keep that risk, and the team leader gets indemnity from that particular team member, but by and large they get to use it as it relates to that particular project. And Kerry is going to talk to you now about issues that come up in the event the team is successful and gets the award.
Thanks, Kory. Yeah, I mean, now you've got the award. It's like, okay, now what? And a number of things that come into focus once that happens. Some of the things that we want to cover in looking at the post-award side of things is, who's going to do the negotiation of the contract with the owner, who's going to be responsible for communicating with the owner, will there be awards of subcontracts, and if so, to whom? If there are disputes over that, how will those be handled? And what, if any, remedies are going to be available to the team members in the event they're disappointed with the outcome in any of those scenarios. So first off, I think it goes without saying that in a team situation, it's critical in communicating with the owner that the team speaks with one voice, and that the owner is able to rely upon that voice and is confident in the authority that that voice has in terms of acting for and binding, if you will, in some respects at least, the team in terms of the proposal. And so the ConsensusDocs 296 addresses that and basically provides that the team leader will be the conduit for all communications with the owner. That makes it clear and hopefully sets up a default situation that is consistent with most teaming arrangements as far as we know. Certainly that's consistent with those that we've dealt with and those that we've come into contact with over the last several years. And at the same time, of course, the challenge in that is you need to be able to speak. You need to be able to speak with the team members and the potential subcontractors in mind, because in many cases they have the technical systems, they have the design, they have the details that are going to be persuasive in the owner negotiations. And so the task given to the team leader is to accurately and completely carry the water in a way that gets the point across to the owner and fairly represents the abilities and the commitment of the team and its individual members. The ConsensusDocs 296 also addresses then the responsibility for both the negotiations of the prime contract as well as the communications with the owner, as I mentioned earlier. Those, to some extent, are the separate sides of the same coin, but this document makes it clear that whether it's communications about the terms contained in the prime contract or communications on any other topic, it's the team leader's responsibility, and they are the ones with the authority to do that. The next critical post-award issue that we want to talk about for a moment is one which probably is the most popular when it comes to disputes. It can be the source of disputes, and in my short 30 years of doing this, it's been the primary source of disputes among team members. Is the question being the conditions under which and the terms under which subcontracts are going to be awarded to team members in the event the team's proposal is accepted and a contract is awarded to the team leader. And I think as you know, Kory alluded to earlier, this is you know, something that is and we'll certainly address it more later on, but it's certainly something that has and continues to be one of the key matters to address when you are contemplating entering into one of these teaming arrangements. Need to know what the exit strategy is, need to know what the end game is, and understand what your rights are, if any, in the event of an award of the owner contract. So a couple of things, obviously, is when you look at this, a couple of questions. One is whether the team leader is obligated to award subcontracts to any of the team members at all, and secondarily, if they are obligated to do that, on what terms or conditions are they obligated to make the award? And so, you know, this is where the rubber really hits the road, and whether it's the prime or the sub who's slamming on the brakes, the opportunity for disputes here is quite obvious. So the approach taken by the ConsensusDocs in the 296 agreement is that if the owner agreement includes work scopes that a team member has proposed on, then the team leader and the team member are obligated then to negotiate a subcontract in good faith. Now, if you stop there, you might be convinced that you have a pretty solid basis upon which to say, I'm good. I get the subcontract. We're going forward. The other side of that coin, of course, is that if in the event that the good faith negotiations are unsuccessful in bringing the team leader and the team member to agreement on all of the terms and conditions under which the subcontract work would be performed, the team leader then has the option and the right to end the negotiations and seek out another contractor with whom they can enter into a subcontract for the performance of the work on which the disappointed team member proposed. So that, again, ultimately seemed to be the norm in the agreements that the drafting committee had been involved with and had looked at over the years, and that is how we ended up at that point. Obviously, if the parties are interested in a different result, it behooves them to articulate clearly what those expectations are and to include the details such that you are ending up with an agreement that begins to look more like a subcontract, which you certainly would be free to agree upon and attach as an exhibit even up front in order to eliminate any question about this ability to successfully negotiate the terms. And again, we see a lot of variation in that. We see a lot of flexibility typically included in these teaming agreements. So to say that there is a preferred default position on that would be overstepping the truth. I think that, of course, that whole issue, of course, then raises the subsidiary issue of dispute resolution. To the extent that there is a dispute among the parties, among any of the parties, to the teaming agreement, there are several questions that come up. First off, what law is going to govern the dispute? Secondly, what is the procedure for resolving disputes? Thirdly, where are you going to resolve the disputes, and in what kind of a forum? And so there are a number of questions that typically arise. And again, this is an area in which the drafting committee saw a great deal of variation and no real consensus on how it is handled. And so the result of that is intentional, but the result of that is that the choice of law provision in the 296 agreement designates the place of the leader's office as the jurisdiction whose law will govern any disputes arising under the teaming agreement. And so the law in effect at the location of the leader's office is the law that will govern. Now, Kory always beats me up about this, but I can't help it. It's one of those things I always like to raise, and that is there are a number of aspects of a law which, regardless of what law you designate, the law of the place of the project may in fact be the controlling law, regardless of what you've said in your agreement. Good example of that, licensing. If you happen to be proposing on a project located in a state that regulates the submission of bids and requires licensing in order to even make a proposal for a project in their state, you may be in violation or not, but you may be subject to that law, even though you've designated a different state's law to govern your agreement, because now you're dealing with a third party, an outside entity who is not necessarily governed by your teaming agreement. And so those are things that, while they're not all that complicated, they are something that it's necessary to keep in the forefront of your mind when you are sorting out the governing law that's going to be involved in your particular agreement. Now, the second issue that we talked about is what are the procedures for resolving disputes among the team members. And in the 296, the drafting committee basically arrived at the conclusion that it was probably best not to specify any particular dispute resolution method. Again, a number of reasons for that, but initially, when you look at these teaming agreements, they're used for a wide range of purposes. Not everyone who enters into them views them as being a document that is exhaustively articulating all of their rights and obligations and is going to be the basis for their legal rights and responsibilities going forward. And so the idea that you would then specify dispute resolution proceeding and give rights and remedies to the parties is wholly inconsistent with this being a very informal and upfront set of guidelines as opposed to a hard and fast agreement that spells out everything the parties are going to do in detail. And so with that broad of a reach of these agreements, the drafting committee concluded that it was best not to specify. Now, obviously, the other issue that we talked about was where your dispute's going to be resolved. And the venue issue and the forum issue, and again, the 296, the drafting committee did not specify anything, again, for similar reasons. It seemed inconsistent with the broad nature of the uses that this agreement might be put to. The last thing that we want to look at in terms of post-award issues, all right, are what we'd refer to as damages or remedies. If you assume you've included sufficient details in your teaming agreement to make the obligations legally enforceable, and if you assume that you have contract claims that are arising out of the agreement and its performance by the team members, the next question is, what are your remedies? When you look at the case law on a lot of these types of agreements, and again, the cases are as varied as the agreements are. So drawing hard and fast conclusions from them is a dangerous proposition. But having said that, I think one of the themes that comes through from those cases is a theme of damages being very difficult to calculate in these situations. What is the value of not being awarded a subcontract? What is the value of not having the opportunity to perform a particular scope of work as opposed to some other scope that you were awarded? What is the damage for any of these types of expectations that the parties have going in? And so what we see in the cases is, yeah, you may have been hurt. Yeah, maybe there was a breach if it's enforceable, but the damages you're proposing are completely speculative and very difficult to prove. And so the upshot of that really is that you have to look at these things when you're drafting and when you're considering your rights and remedies. You need to do so with an eye toward what's the end game, what's the exit strategy, what is the value of my participation in this. And so you have to find ways then to address that can be recognized in the law to the extent you're involved in an enforceable agreement. We look at some of the potential sources of your rights and remedies in these situations, one of which is the confidentiality agreement. And again, in these agreements, very typically, damages are not really the primary remedy. The primary remedies are more injunctive in nature. They are forcing the return of information, expunging information, prospectively prohibiting communications or disclosures, and usually stipulating to the inadequacy of legal remedies and stipulating to the entitlement of the parties to some type of injunctive remedy. And so the key there is to specify what relief is to be had, stipulate to those elements to the greatest degree possible, and agree on the remedy that would be most appropriate. And obviously, that's a lot easier to do going in on the front end than it is once a dispute develops. So, similar conversation could be had with respect to the non-solicitation of employees. Perhaps in that case, you can articulate and quantify training costs or things like that might be a damage, but again, they're not going to be nearly as significant as the loss of that employee's technical knowledge and value as a human resource. And so, again, specifying liquidated damages or specific performance type of remedies, again, depending on your situation, may be the best approach. With regard to the award, non-award of subcontracts, again, we get back to the enforceability issue and what the parties truly intend here. And that's why it's so important to, if you want a different result, if you want a very predictable result, it needs to be articulated in that manner. And again, when it comes to a remedy for the non-award of a subcontract or the refusal of a subcontractor to enter into a subcontract once the prime contract's awarded, the remedies available to the sub or to the prime are, again, difficult at best to quantify in most instances. And so, again, to the extent that there can be agreement on or a liquidated damage or what the exact remedy is, the more likely that your rights then actually have some value to you. I think the other thing is to look at here is absent your own ability to specify liquidated damages or some other particular remedy, what outside of that might there be that would be a limitation on damages? And I think importantly in the 296 there is a waiver of consequential damages. And I think when you look at many of the types of damages that we've been talking about, to the extent you were to try to quantify them in a dollar amount, you would find that they fall within most definitions of consequential damages. And so with this waiver in place, what have you left? And so that's why the waiver is worded the way it is. There are some exceptions to it in terms of losses that are covered by insurance, to the extent to which the owner agreement flows through any consequential damages, and other provisions in the teaming agreement which specify remedies that may otherwise be characterized as consequential. And so, again, back to my earlier caveat, if you want it, you'd better specify it in the agreement. Kory?
We talked about pre-award and post-award. The other category, which we'll just spend a minute on, is what happens if one of the team members withdraws. What are the consequences and implications of that? Briefly, as we said earlier, the 296 says you cannot participate unless you're part of the team. So once you sign the agreement, if you withdraw, it doesn't mean you get to go separately compete against the team and submit a bid in your own name or team up with somebody else. Can't do that. If you generated documents and then you left the team for whatever reason, again, same concept. You have to transfer a non-exclusive limited license in those documents to the team leader so the team can keep moving forward. And lastly, with confidential information for everybody else who's on the team, it's 30 days from the end of the project or termination or non-award. With withdrawing team members, 7 days is the default rule. They acquire any confidential information, they've got to give it back sooner than the rest because there's no reason at that point for them to have it. And so those are some of the small issues that can come up with a withdrawal of a team member, but nonetheless the 296 deals with that to some degree in the event that happens. And so now with that, we've kind of been through the issues. The last thing we want to do here is talk about some of these decisions, and if you want a certain result, how might you be able to try to push the terms of the teaming agreement more in your favor to accomplish that. Starting first with a couple of relatively recent cases. And these are not necessarily unique, but they're recent and they're representative, so we thought that we'd be good to talk about them at least for a minute. The first one is the CyberLock case, which some of you have probably heard about. And the other one is the X Technologies case, the X-Tech case. I actually want to talk about the X-Tech case first because it deals with teaming agreements at the pre-award or prior to an award. At that stage, CyberLock obviously comes into play after the award has been made. So the X-Tech case, very simply, you had two firms, X Technologies called X-Tech, and this other company, Marvin Test Systems, they went by the name Geotest. So you had X-Test and Geotest decide to do what many of you have done and or contemplating doing. They signed a teaming agreement. And they're going to go pursue an award with the Air Force. And so the teaming agreement that they entered into had an exclusivity provision similar to the one in the 296 that says you're not going to go team up with somebody else and compete against the team. That's what it says. So for whatever reason, Geotest teams up with X-Tech and they submit a bid. Separately, Geotest then submits a second bid in its own name. And they teamed up with a different company, although they didn't really team up, they just got some licensing. And so the Air Force then awards the contract to Geotest on the bid that they submitted in their own name. So that's raising all the issues we just went through. What do? X-Tech filed a suit against Geotest saying, I should have got my share of what I was going to do in the teaming agreement. And they never really got to all these other issues that we talked about on post-award, because what the jury found in the court upheld was that X-Tech, or Geotest rather, in submitting and obtaining the award in their own name, violated that exclusivity provision. And so the result of the case, X-Tech won several $100,000, and that was upheld. Now the cases vary on that, but in that particular instance, we see a general theme of the courts to uphold the enforceability of these teaming agreements insofar as it relates to we're only going to pursue the award as a team. And so in that instance, that was not abided by, and the other team member that got left out received an award. Now, what would have happened if they, would have just tried to negotiate and couldn't come to terms on a subcontract? Different issue. But here, the sin that was made was violation of the exclusivity provision, and so that in and of itself was a breach of the teaming agreement because it was clear on that point. You flip to the other side of the backside, the post-award. Now we have an award. That's the CyberLock case. What happened in that case? CyberLock was a sub, an information expert was a prime. In that context, they entered into a teaming agreement to obtain an award from the Office of Personnel Management, the OPM. Information expert was awarded that contract. So in other words, it was successful. They teamed up and they got the award. Then come the time of CyberLock says, what about my subcontract? They negotiate for a month on that. They come to an impasse, and information expert terminates that relationship or does not subcontract to CyberLock. They move forward with somebody else, and thus CyberLock sues. Now, interesting fact on that case is these two entities had successfully teamed up in the past on other projects, had obtained the award, had entered into subcontracts, and they had been successful. On this particular one, another thing to note, in the previous agreements, the previous relationships, they had attached a copy of the subcontract that they were going to enter into. On the particular case in question that we're talking about now, for whatever reason, they did not do that. And so when it got to the court, this was a court applying Virginia law, they said, as Kerry mentioned earlier, agreements to agree or to negotiate open issues are not contracts at all. You either have a contract or you don't, this particular court's eyes, and many others. And so here they held an agreement to negotiate a contract is not an agreement at all, and thus it was unenforceable. And so one other thing that was noteworthy in the CyberLock case is it had an integration clause. What is an integration clause? That's the clause you see in a lot of contracts that says this agreement supersedes all other, prior written understandings. And so it's an effort to have the agreement say everything that is agreed upon. And so in other words, if words were said or notes were exchanged or prior agreements were made, those all become irrelevant when you have an integration clause. Why do we tell you that? Because the 296 has the makings of one. It says that the 296 teaming agreement is intended to be the complete understanding of the parties. And so the CyberLock case, it's pretty typical of all the disputes we see post-award. One, the subcontractor says, I didn't get my fair shake, and the team leader or the prime says, we tried, but your price is too high or your scope is wrong or whatever the case might be. They don't enter into a subcontract, and thus it's left to the lawyers. The CyberLock case is up on appeal right now, further appeal, and so that case may come out the same or we may get a different result. We're waiting to see what happens with that. But the CyberLock case got a lot of press, but it really wasn't anything new to those of us who have dealt with teaming agreements, because that's not the first court to say an agreement to agree is not enforceable. And thus you have the tension of is there an obligation to award subcontracts to the team members? That issue still persists. We're going to talk about that for a minute on how you might be able to change that result if you intend to. One other thing I'll note, there's some other recent cases with facts that are similar to CyberLock that have come out the other way, where courts have said, yes, notwithstanding the promise to negotiate a subcontract as being an agreement to agree, they found enough other things that there was an intent to be bound by that. And so this is really an issue that varies court to court, state to state. And so when you're talking about the governing law of this agreement, as Kerry mentioned earlier, the default is the team leader's office. You may want to specify the law of a state that is favorable to teaming agreements or not, depending upon your perspective on that. And so that's sort of the recent legal landscape. Again, nothing that's earth-shattering in that sense, but it's caught a lot of attention because now everybody's questioning whether teaming agreements are enforceable on the back end, and the question is maybe, but that's always been the case, kind of depending on the particular state and the governing law. So if you are of the inclination to say, how do we draft a teaming agreement that is enforceable, what does that look like? We're going to spend the last few minutes here talking about a few considerations you might incorporate depending upon your perspective. First, just generally, as we've noted, this is an issue that varies state to state. But is there any common themes that exist? There are. And the essential terms that courts tend to want to see in these teaming agreements to make them binding, again, more so on the back end, do we have to award a subcontract, is what is the work that's going to be performed? How much are you going to get paid? How much of it are you going to do? How long is it going to take you to do it? Are sort of the key essential terms that courts look for. Certainly if you attach a subcontract with all these terms in it and can agree on a price, you are a long ways towards fulfilling a lot of those obligations or a lot of those terms. Again, the 296 contemplates that you might do just that with the Exhibit A attachment. And certainly you can do that. But again, a lot of these projects are not at a point in time in terms of the design or in terms of enough information that folks can really do this in every instance. And a lot of reason why teaming agreements get entered into is because the requirements are not perfectly defined, or there may be some performance criteria. There may be any number of issues that preclude a definitive scope of work for each team member. But we've got about 10 minutes left, and so we're going to run through a few considerations that you might consider, both from the perspective of a prime contractor team leader and a subcontractor.
In terms of the prime contractor's perspective on these things, it's not unusual that the prime contractor is going to want to avoid getting caught in the squeeze between the owner's budget parameters and the subcontractor's price parameters. And so they want to maintain flexibility, and so typically what we'll see is the team leader wanting to maintain a high level of subjectivity in the agreement, a high level of condition on any obligations of the team leader, and maintaining of a fair amount of discretion in the team leader with respect to their ability to enter into a subcontract or decide on a scope of work or decide not to go forward with any particular scope or team leader. I think some other examples of that are in the cyber law case, or one of the cases we looked at, there was a specific time period attached to the negotiations obligation of the parties with respect to a subcontract. They couldn't reach an agreement within 30 days after the award, then the deal was off. And so there again was the ability to have a very specific drop-dead date at which the team leader was free to pursue other opportunities. The ability to withdraw unilaterally from or terminate the teaming agreement in the team leader's sole discretion is another way that they oftentimes will try to condition that. And as we talked about earlier, the disclaimer of any consequential damages or limitation of that goes a long ways toward insulating the team leader from any real liability in those circumstances that they want to avoid.
Looking at it from the other perspective of a sub of CyberLock, or someone who wants the team leader or the prime to be bound to have to award the subcontract, what are some things that would be helpful in that regard? Well, just the opposite of what Kerry just mentioned. Obviously, an unqualified commitment is helpful in that regard. Contrast that against the 296, which says we're just going to negotiate in good faith. Again, the 296 is intentionally drafted that way, but you could alter that to say you shall award in the event that prime is successful, team leader is successful, you shall award a subcontract on these terms and for this price. You can do that. Additionally, to make these things enforceable, you want to eliminate any time limits to negotiate or execute a subcontract, so 30 days or something. You don't want anything like that. You just want it to be unqualified. You shall award the subcontract. Similarly, you may want to put in a disputes provision. We talked about the 296 doesn't have one. You certainly could put one in and say, here's what's going to happen, or here's how we're going to resolve this in the event you do not award the subcontract or we have some other issues. That's a theme that we've seen from courts as tending to favor more towards enforceability. What are some other ones? Well, certainly you could put in an exit fee or a liquidated damages provision that Kerry has talked about. If you don't award me a subcontract, we agree up front, here's what my damages are going to be. Certainly you could draft that. You could come up with a method on how you're going to determine your prices. Maybe it's a unit price, or maybe it's some other basis to calculate the scope of the work that you're going to perform. Again, another factor is this governing law. Given the CyberLock case, you may not designate the Virginia as the governing law if it looks like the 296. Certainly there are some other states that are more friendly, but the key, I think, is more in the terms of the teaming agreement itself. Do you want it to be enforceable or not? And if you attach all of these terms, certainly it could be enforceable even in Virginia with CyberLock and other states who have held similarly if you put all these things in there. Lastly, we talked about the integration clause. Not having that can potentially be helpful because then it may allow a court to consider maybe there was an agreement between the parties. It didn't get put into the actual teaming agreement, but maybe the parties separately had an understanding on that. You can consider that kind of evidence if you don't have an integration clause, perhaps. And then similarly, just coming right out and saying this is not an agreement to agree. There's valid consideration. Both sides are foregoing opportunities here, and both sides intend to be bound by this agreement. That kind of statement can be helpful when the court looks at this in determining whether or not the parties really intended to be bound by this sort of an agreement. And so we've left, I think we're right on time, we left about 5 minutes left. Kerry, Filiberto, I don't know if there are any questions. We could take those now, and if not, we'll leave you to conclude.
That sounds great. We do have one question in queue, and another one that had come up that I answered directly, and just wanted to let the folks know that the 296 is actually not quite published. The working group finished all of their work, and we really appreciate everything Kerry and Kory and everyone else did on that, but now it's out to ballot. Being a coalition of 39 organizations, we need to send it around to everyone to vet and do the final look over and that sort of thing. So it is currently out for ballot. However, the 498 ConsensusDocs teaming agreement for design build is currently published, and we use the basis of that to modify it for the traditional design bid build process. So take a look at the 498 and the 296 will be coming out shortly. And so our question to the speakers is, what tips do you have for preparing a teaming agreement covering multiple projects, including projects yet to be identified by the parties?
Well, certainly that's not something that we typically have seen. Doesn't mean you can't do it. In my mind, it gets a little bit more difficult to, if you want it to be enforceable. That is, the team leaders, in the event of award or multiple awards, is obligated to subcontract to the team members. Certainly defining the scope and what you're going to do of an unknown project becomes problematic. Certainly, if it were me, if there were a way to quantify either by unit price or a different way on how you're going to determine the method of calculating the cost of those services, certainly would be a step in the right direction, but it's going to be hard to put in all of the nitty-gritty details on projects that are unknown.
Yeah, I think one of the things that those agreements contemplate is an emphasis much more on the other aspects of the teaming arrangement. That is, the other aspects being the exclusivity aspect of it, the obligation of the team members to search for and find opportunities that are good teaming opportunities, the obligations of the parties with respect to non-disclosure and such. And so I think just like in the cases that we talked about, while perhaps the obligation to subcontract may not be necessarily enforceable in all cases, the other aspects of these agreements may well be enforceable, even if the subcontracting aspect is not. That is to say, you may get busted for breaching the confidentiality provisions, and you may get busted for the exclusivity breach that we saw in the XTEC case. And so, again, just because there are aspects of these things that can be characterized as agreements to agree on those topics does not mean that other aspects of the agreements may not be enforceable. And so I think it's those other aspects that really are the subject of these longer-term, longer-view, multiple project teaming agreements. The other thing I would say, putting on my dusty old antitrust hat, is that those types of long-term agreements, absent developing technology or R&D aspects that you can claim as a reason for this type of a teaming arrangement. Absent those kinds of justifications, I get a little more nervous about the antitrust aspects. But typically that's where they're used, is where you have perhaps long-term research and development type projects in the offing.
Well, thank you very much for that. I don't see any other questions in queue, and so I'll move forward with my closing here. And if something comes up, certainly the questions are more important than my closing. But I do want to thank you, Kory and Kerry, very much for a very informative presentation. And I want to thank our participants for joining us today. We hope this webinar helped you learn how to effectively use the ConsensusDocs teaming agreement to further your businesses. A lot of folks have been asking, will we get a copy of the PowerPoint? Yes, you will get a copy of the recording that has the audio synced up with the video. Give us a few days to get that together, and then that will be emailed out to you. Wanted to remind you that ConsensusDocs are the only standard contracts that are written and endorsed by 39 leading design and construction industry associations. Each contract in the ConsensusDocs family was crafted and reviewed by a team of professionals with a combined hundreds of years of practical and legal experience representing all stakeholder interests. Should you need additional information on ConsensusDocs, feel free to reach out to us via our website. Give us a call at the toll-free number on your screen right now, or feel free to email us at support@consensusdocs.org. Finally, we'd love for you to take a moment to complete the evaluation form that should be emailed to you directly from our system after this webinar. Your feedback will help us plan future ConsensusDocs educational events. So it does not look like we have any other questions that came in. So again, thank you, Kory and Kerry, and all of our attendees. And this brings our program to a close, and I hope you all have a wonderful afternoon.
Thank you, folks.